Welcome everyone. So this is Vision IAS magazine and this is of September 2022. Today I will be explaining polity and governance section. So first is Criminal Procedure Identification Rules 2022. So there is Criminal Procedure Identification Act, CPA Act, which is enacted in 2022. So Ministry of Home Affairs has notified the rules about this act. So about the rules, so it has laid down the procedure by which measurements such as footprint impressions, finger impressions, photographs, etc. can be taken of convicts and other persons for the purpose of identification and also investigation procedure. Key features of the rules are: firstly, it will take measurements. So measurements will not be taken, or measurements will be taken only if a person is charged or arrested in connection with any other offense. It means measurements will not be taken if a person is not arrested firstly and if a person is not charged with any kind of offense. Then authorized person is there to take measurements. It means authorized person such as a registered medical practitioner or any person who is authorized in this behalf. These persons are only eligible to take measurements. Not every person or any kind of person can take measurement of the person convicted or arrested. So it has given a rule making power to NCRB. It has empowered NCRB. Or also, if a person does unauthorized access to that particular data or measurements of the person convicted or arrested, or if it distribute that data to any other person, then it shall be a punishable offense under IPC 1860. So what are the concerns with the notified rules? So concerns are that the rules are restricting the grounds. It means it has not given a certain ground or certain criteria under which person's data may be collected, and also it does not define who is eligible or which person can take that such kind of measurement. It has not defined any kind of official in that, and it has also given excessive power to NCRB, which kind of violate the principle of separation. It means the entity that is being for guidelines, issuing guidelines, and the entity which follow the guidelines. So it halt the separation. And also Act empowers NCRB for suo motu destruction. Suo motu destruction of records means NCRB can destroy any record of any person convicted or arrested. The sole responsibility or power is given to NCRB, and it takes action about destruction of records without discussing to any other authority. It means it has given NCRB a huge power, and also the rules put the onus on the individual to request for such destruction. It means it puts the onus on the individual. It means that the person who is convicted or who has been found guilty, then if he wants to destroy his record, then he has to request for it. Then after request, record is destroyed. So it puts sole responsibility on the individual, so which is a concern. It means there is no authority responsible for destruction of the record. Next is about Criminal Procedure Identification Act, about which rules have been notified by MHA. So this act comes with the end of an act, that is Identification of Prisoners Act 1920, which is a kind of colonial time act. It was enacted when India was under British power. So this particular act, which is enacted in 2022, it has expanded the scope for measurement. It has also expanded the ambit of measurement such as fingerprint, photographs, etc. So it has expanded the scope of that. It will help in unique identification because the rules or the procedures that are like given in this particular act are more tightened than the previous prisoners act, which was enacted in 1920. So it like gives unique identification by which two persons are not like confused between and also it like fulfill the demand of the investigation. So scope and ambit, if there is expanded, it is earlier only like fingerprint, footprint, photographs were taken as a kind of measurement. But now under this act, Criminal Procedure Identification Act or CPA Act, it is now extended to iris and retina scan, signatures, handwriting, etc. And what are the key provisions of the 2022 Act? So it had expands the ambit of certain provisions. So it has expanded the type of data called the measurements. Like I have already explained earlier, it has only contained fingerprint, footprint, photograph. Now it is extended to iris, retina, biological sample, such as blood, semen, hair samples, which are collected for severe like severe cases or severe offense. So it like person from whom such data may be collected, and also the authority that may authorize such collection and the rule making power. So it has given an authority, so it has expanded the ambit by this. Then retention of details, so it requires details to be collected for 75 years. So if a like data is collected for 75 years, then definitely it will help in investigation procedure, because like DNA samples or other things, biological samples are also collected, and many things like fingerprint, they are used because if a person commits an offense one time, then he or she can also commit an offense another time also. So in that case it is helpful and useful also for investigation purpose. Now it also the record may be destroyed in case of persons who have not been previously convicted. It means if there is a person who is found to be suspect, only suspect, and then court declares that he is not guilty, so his records will be destroyed. If he has not found guilty of any other case before that current case, then there is a resistance. If there is a resistance or refusal by any person, if any person resists or refuse to give details, give measurements, then it will be considered an offense under IPC 1860. Now this act also empower NCRB because it is responsible for collection of details about a person, about the measurements of the person. So now we need to compare between key provisions of the 1920 Act and also with the key provisions of 2022 Act. So it is like a time span of 100 years. So we need to examine what changed between this act and now this act. So there are certain parameters. First is the data permitted to be collected. Earlier in 1920 Act, only fingerprint, footprint impression, photographs were collected. But right now in 2022 Act, biological samples are also included. Biological samples such as blood, semen, hair samples, and swabs, and also DNA profiling, these are also there. Iris and retina scan is also there, and also there is behavioral attributes such as signature, handwritings. Earlier this was not included. Now under section 53 and 53A of CRPC, which include offences against women, in that case biological samples also need to be collected. Then next parameter is the person whose data may be collected. So it has also been expanded. In 1920 Act, person whose data may be collected was limited to certain parameter, but now it has expanded. Firstly, it was the person whose data may be collected, either the person is convicted or arrested for offense, and that kind of offense which is punishable with 1 year or more. But now convicted or arrested for any offense, it means no time duration like 1 year or more, any offense, whether it is 6 months, 3 months, anything. Biological samples may be taken forcibly only from persons arrested for offences against a woman. If there is an offence against a woman or a child, then biological samples may be taken forcibly. Or if the offence has a minimum punishment of 7 years imprisonment, so then also biological samples can be taken. Then in that, magistrate may order in other cases collection from any arrested person to aid criminal investigation. But in 2022 Act, a person on the order of magistrate from any person, not just an arrested person, to aid investigation. It means the person who is also not arrested, biological samples or measurements can be taken so that investigation procedure will be eased up. The next parameter is persons who require direct collection of data. So there is an investigating officer under CRPC, officer in charge of police station, and rank of sub inspector or above. But in now 2022 Act, the person who can collect data, it is now for the rank of head constable or above. So it has now expanded its scope because it has given more people a kind of power to collect data. Also, head warden of the prison can also collect data. Then rule making power with regard to manner collecting details. So it is vested in only state government. Now under this act it is vested to both government. It means state government also and also central government. Next we will look at what are the key concerns with the act. So there is a concern that it may violate right to privacy act. So on 2017 the Supreme Court recognized right to privacy as a fundamental right guaranteed by the Constitution. So this particular act may not meet the SC judgment on that. Amounting to forcible extraction. So this act attaches criminal liability. It means if a person resists or refuses to give measurement, then he is considered to be doing a kind of offense. So this is also a problem or concern with this act. Also, it is a kind of violation of an individual's right against self-incrimination. So here I will tell what is criminal liability. So criminal liability is if a person resists or refuses to give measurement, then this is kind of then offense. There is a consideration of an offense. The right against self-incrimination. So in Article 23 it has written that no person accused of any offense shall be compelled to be a witness against himself. It means a person who is accused of any offense, it means who is only a kind of suspect, he cannot become itself a witness against himself. But after collection of measurements of the person, a person may be called witness against himself. Then there is also a possibility of misuse of this act because act allows for measurements, and also this allowed measurements for even petty offences. It means also for minor crime for which punishment is like a small fine or some kind of short-term imprisonment. Then what is the limitations? It is also concern limitation of NCRB. So NCRB is ill-equipped. In what term? Although NCRB has been empowered but it is ill equipped with the quality management of the measurements. Then also predictive policing, it means in predictive policing it uses like algorithms to analyze information so that it can predict future crimes and also prevent it. So analysis behavioral attributes are helpful for predictive policing, but it may also go beyond like recording of core measurements for predictive policing. The next topic is prison reforms. So National Crime Record Bureau NCRB, it has released a kind of prison statistics PSI report. So firstly we need to understand what has been written in this report, which is released in 2021. So about this report actually what this report says. So in this report data like numbers or available capacity of the jail and also jail officials strength and their training and also the prison budget which is being designated or the expenditure on the prison, these kind of data are provided in this report. So what are the key findings of the report? So key findings of the report is that out of 10 prisoners in Indian jails, 8 are awaiting trial. It means 8% out of 10 persons are being held in custody and they are awaiting trial for the crime. Uttar Pradesh jails record the highest number of under trials. Then jail staff is very low. Vacancies are there, but vacancies are not filled up. So it is a kind of understaffed. Then budget for 2021-2022 has increased 13% in comparison to previous year, which is a kind of good sign. Then about prisons in India. So administration and management of prisons, it is the responsibility of a state government. So under state government this matter comes and it is governed by Prison Act 1894 and also prison manuals, and also Ministry of Home Affairs provide regular guidance and advice to states and UTs on various issues. Prison has evolved from retributive approach. So it is about prisons in India. So prison has evolved from retributive approach. It means a retributive approach is a kind of approach in which criminal justice focuses only on punishment. So it is based on the idea that criminal can become again a moral person by the way of severe punishment only. So it basically focus on the punishment, like a criminal can only be corrected by giving her severe punishment. But now prison has evolved from this approach. It has evolved to a concept of reformation and rehabilitation of offender. It means in reformation and rehabilitation, reformation will help offenders to stop their criminal behavior, and rehabilitation is a kind of process of re-educating criminals. So by their re-education they will certainly get moral behavior again. And what challenges in prison governance we face? So prisons are very much overcrowded, so it will adversely impact hygiene, management, mental and physical health of inmates. It means if in a one room there are a lot of person living, then obviously hygiene will be impacted. And also if there is a spread of communicable disease like COVID-19, then there will be like a huge pandemic. It will impact the prison in a bulk amount. Majority of prisoners who are in prisons, they have not been tried, they are under trial. And also legal aid is also not provided, lawyers are not provided, and due to this they consistently spend in jail for very several months, like 7-8 months, and they have not been given a single trial in fact. There is also a staff shortage. Prisons in half of the states and UTs at the end of last year, it was functioning with, it means one-fourth positions were vacant. There was a vacancy of one-fourth positions. According to National Human Rights Commission, in the last decade, on an average, 5 people died in judicial custody every day. It means every day 5 people died because due to torture which is given in the jail. So this commission said activities like trafficking of mobile phones, like giving of mobile phones from outside to inside the jail, and also drugs peddling, and also uh, weapons inside the prison walls. It, like in the exchange of bribes, it also poses threats to national security. Women inmates are mostly illiterate who are arrested on petty charges, so they are not aware about legal procedures, so they are misguided, and also they become vulnerable to custodial sexual abuse. And what is the way ahead? So there is a manual which like guide about the prison, like the functioning of the prison. So this manual aim at bringing basic uniformity in laws. It means from Jammu and Kashmir to Kerala, there has to be like basic uniformity. Laws should be uniform, equal in every state and UTs, and also rules and regulation that govern the administration of prison. There should also be uniformity in this, and management of prisoners all over the country. Then there should be a biometric identification facilities, fingerprint, and also CCTVs must be there, so that escape from the jail or any kind of illegal activity can be tracked down. There should be hospital sanitation system. They are must needed. Timely and complete production of under trials before the court. So there should be speedy trials. At least initiate the trial procedure, because there is a problem that people are found suspect, they are arrested now, and they have been in the jail for so many months, like 7 to 8 months, and not a single trial has been done. So at least initiate the trial procedure. Now there must be a system of plea bargaining. So in plea bargaining there is a negotiation and agreement to reduce the punishment of an offense. So this system should also be introduced. Then Lok Adalat could be involved for constant monitoring of prisons, so that it can monitor the functioning of the prison, like how many staff is there, how many it is not overcrowded, so that identify the shortcomings, like problems which prison is facing in its administration. Currently applied methods use torture as a tool for investigation. Like if a person is suspected, then people or official try to like torture to for like saying truth in front of these officials. But this should be altered, and there should be priority to human rights. If a person is suspected or person is uh, charged with an offense, then he is also a person, and human rights are also for him, so it should be enacted. So now the next topic is internal party democracy. So firstly we need to understand about internal party democracy. So the methods, it means like there is a democracy in which there are so many parties such as BJP, Congress, BSP, SP, and Trinamool, and so many parties. But in the internal party democracy, it seeks to understand, or like mechanism of the system inside a party, of a one particular party, which is like BJP, Congress. So it is understood in that. So only section 29A of the Representation of the People Act 1951, it only mandates the registration of political parties, and Election Commission of India is not equipped to regulate the functioning of the political parties. Like he is not empowered for the functioning of the political parties. And what is the need for internal party democracy in India? So it will ensure equal representation. So like if persons inside the party are not treated equally, like our country is a democratic country, it has the principles of liberty, equality, fraternity, and if persons are not treated equally, so there will be a problem in, and it will disturb democracy. So we need to ensure that there is an equal representation inside the party system. To prevent dynastic politics, it means there is a growing nepotism. It means only king's son will become king. This should be stopped, and data has suggested that this has been there. It means like MPs all below the age of 30 in 15th Lok Sabha, like all of them were from political families. It means below the age of 30 MPs, there was no person who was from a normal family. So there is a dynasty, there is a nepotism in politics, and we need to prevent it. Like normal people will also be given opportunity to represent the people as a representative, as an MP, MLA. There is no well-defined process for the distribution of tickets to candidates. It means no rules are given, like how tickets will be distributed. Only it has been found wealthy person are given ticket, or politically powerful person are given ticket. So this is also a problem. It must be reduced, and it also enhance kind of criminalization. Candidates which have adequate social and financial resources, they are given importance for ticket. It should be removed, it should be corrected. Every political party has a state and local body units. So each party, like if there is a party BJP, then it has in the state government, if the state government is also a BJP, then this will on the state level, local level, it come like municipal government and also many other things. So election at each level, it will ensure power centers at different levels. Like tickets should not be like decided, or any other functioning should not be decided from only the top of the hierarchy, but it should be decided within the, like if there is a local body election, and local people should decide their own of the party. So they should also be given a kind of responsibility. Then what challenges for setting up internal party democracy? So challenges what we face, it is in the case of Indian National Congress versus Institute of Social Welfare 2002, Supreme Court held that Election Commission cannot take any kind of action against political parties for violating the principles of inner party democracy. So Election Commission of India is not given adequate power, which is a problem. There is also no legal ground, like legal rules or provisions in the constitution on which elections can be mandated within political parties. Like there is no constitution rules by which provision of tickets should be there, or other like positions in the political parties, or other things, other matters can be mandated. So next challenge is most of the parties are openly caste and religion based. Like they have an agenda to partition the people by religion or caste. They open up caste agenda, and their finances are also opaque. Leadership in political parties is also decided by only few people who are in a leadership position. So this should also be corrected. And what is the way forward? So way forward is like political parties should be given can be given constitutional status. It means in our Constitution of India, the functioning of the inside the political parties can also be there. So it will give a kind of legitimacy to the political party functioning. And it has also an example like Germany. It has given constitutional status to political parties. Then there should be specific provision regarding organizational elections at different levels, whether it is at state, national, local levels, and also the time span of the such elections, and also term of office of the office bearers of the party. Now, internal elections for leadership positions, it means it should be carried out by debate, campaign, meeting, discussion within the party, like not by choosing one person who is wealthy or who is more powerful in politics, or like chosen with any, like not unanimously, only by few people. There should be debate, there should be campaign also, like huge participation of the people in selecting any kind of leadership position. ECI should be empowered because ECI has been restricted to refrained from any kind of political power issues. So it should empower ECI to deregister parties that fail to comply with all the rules. State funding of political parties could bring in equity and accountability among parties. Corporate Social Responsibility Amendment Rules 2022. So government has amended rules governing corporate social responsibility. So what changes it brought about by amendment rules? So changes that are there is the establishment of CSR committee for unspent CSR amount. It means so firstly we need to actually understand what is corporate social responsibility and what are its significance. So corporate social responsibility requires some companies, they have to mandatorily, it means they are liable to spend 2% of their average net profit preceding 3 financial years, and the company which is eligible is the net worth of the company must be 500 crore or more, turnover must be 1000 crore or more, and the net profit should be at least 5 crore or more. So the qualifying company will require to constitute a CSR committee consisting of 3 or more directors. So these company will give the fund of their 2% profit, and this committee will like establishment of this committee should be there, it has been there by these rules for unspent, it means CSR amount which is not used up. So CSR committee will look after it. CSR spending cannot be greater than 2% of all the CSR expenditure or 50 lakh rupees. Whichever is higher, companies have to give brief explanation of its CSR policy, information about the members of the CSR committee, and also web links for the impact assessment of CSR projects. So companies have to give all the details regarding its own individual policy about its about the members which are there in CSR committee, and also their projects which are being enacted for the betterment of the people or any other purpose. So what challenges faced what challenges are faced in the implementation of CSR? So firms try to fund only those projects that are close to their industries, that are close to where they are based, whether they are close to industries or headquarters. So poorer and underdeveloped areas get neglected by this, they do not get benefit of CSR. Now most firms also do not mention that how much money they have spent it on activities, on projects. So it also kind of make difficult to estimate the exact amount of fund which are spent by individual firm. Now Combating various diseases and promotion of education, it accounted for 44% of CSR expenditure, but child mortality received no funding. So it is not reduced, and also extreme hunger and poverty has only a small ratio, which is 6% only, which is so much in the country. So it needs greater attention for the companies to spend on these two problems, that is child mortality and extreme hunger and poverty. And also there is lack of community participation in CSR activities. So there is limited awareness about CSR. It means people are not aware, so they do not seek the benefit of that programs which are being enacted by any company. Companies have also complained that there is a lack of coordination or lack of transparency on the part of local implementing agencies which implement their activities or programs, and also these local implementing agencies do not make adequate efforts to disclose information on impact assessment and also how their funds are being utilized in that particular program. Often CSR initiatives are defined being more donor driven than local in approach. It means because companies are mostly in big metropolitan cities, so local in approach which is local is neglected. People in far regions are neglected by their programs. And what is the way forward? So way forward is companies should engage with NGOs and communities as partners across program design and implementation. So if they will engage with NGO and community, then there will be a coordination between all three, and implementation of their program and designing of their program will also get enhanced because they will share data with each other, they will work together. Taking efforts for communities, for SC, ST, women, people with disabilities. So existing programs do not address these people, so programs must be there for these communities. Companies should hire a professional CSR team so that it can bridge corporate and also social sector. CSR spending should be discussed so that awareness is generated among the stakeholders. So stakeholders are the poor people who get benefit from their spending and those living in deficient condition for whom CSR spending was instituted. So they must be aware. So if they must be aware, then obviously they will get benefited. And also there should be a department in Ministry of for Corporate Affairs at central level, and also there should be a one in Finance Ministry of the state. So that's how problem regarding the CSR will be solved.